Had to get my water. All right. I got 3 hours of sleep last night. Why? Because I got done with most of my homework, and then I couldn't rest because I'm still very frustrated over what has happened to Jack Miller in Olmos Park and what's happening to many people. And so what I did was I think I got home at about 4 o'clock this morning from the law library. I just couldn't sleep. I think I went to bed probably close to 5. And it's like 3 now. I went to bed close to like 5 o'clock. But I wanted to do a lot of research into kind of what a defense would be or what an opposition would be to Olmos Park. And so I just dug through case law. I mean, I just stuck my nose in Texas case law, Fifth Circuit case law, and so there's a lot of information. And I sent Jack tons of cases that I found that are going to be helpful to his attorney. And I wanted to talk about a couple of those. So Jack is charged with 4 crimes. If you want to know what those are, just look at what Olmos Park charged me with. It's the exact same nonsense. They've charged him with obstruction of a roadway or a sidewalk. They've charged him with, and actually, Justin Pulliam has a great video that goes over these 4 charges as well. But obstruction of a roadway, resisting arrest, disorderly conduct, and felony assault on a peace officer. The ones I'm not going to cover today, because look, they're just absurd. The felony assault on a peace officer, we have it on film. When Lopez decides that he's like, oh, you just headbutted me, that's assault. So we know what they're going to try to claim, but guess what? We've got multiple videos that are going to disprove that. Just like when they tried to claim that I assaulted them, there was video that proved otherwise. And you know, this is funny. This is what Olmos Park does. So Olmos Park will hurt you, right? And when they hurt you and you react to the pain, which every individual does, then they charge you with, they get close enough that when they hurt you and you react, that you somehow brush them or, I don't know, somehow touch them. And so that I'm not even going to go into the felony assault on a peace officer. The only reason they charge that is 1, to cover their ass, and 2, because they know it's going to result in a high bond and it's going to force them to pay thousands of dollars. His bond was $2,300. Well, that's what he had to pay. I'm sorry, the bail. The bond was $23,000, but 10% of that's about $2,300. And they know that no matter, even if the charges get dismissed, they now know that Jack is out $2,300, because even when you're falsely charged with a crime and you get magistrated out, and then the charges get to the prosecutor goes, this is bullshit, I'm throwing this out, we're not going to prosecute, you can't go back and get your $2,300 back. You can't. That's the way the system works. The only way you can get your money back is if you make a cash bond. So if he had paid $23,000 for his bond as a cash bond, then he'd be able to go back and get that money back from the court. But as far as going to a bail bondsman, they know that you can't, no person has $23,000 in their bank account. So, hey, if we charge him with felony assault, he'll have a $20,000 bond. And by the way, my bond for felony assault on Olmos Park was $15,000. So, I don't know why they charged Jack with 20 and me with 15, but that's, I don't know what it is. So what I've done is, in the comments or in the video description, I've got case law on at least 2 of the charges, and I'm gonna cover the disorderly conduct because that seems to be getting abused throughout the state of Texas, and I'm also going to cover the obstruction of a roadway because that seems to be the go-to charge for Olmos Park. And so, like I said, I've done a lot of research on this stuff, and I'm gonna start with the obstruction of a roadway and kind of go into this. So this is, now look, I am not an attorney. Okay. I am a law student. And so I want to make that very clear. I'm not giving advice to anybody. I'm just telling you what the cases say. In essence, I'm doing a case brief on several cases on a single issue analysis of two issues. And those issues are obstructing a roadway and or sidewalk, whatever, a passageway, could be anything like that, and the interference, or I'm sorry, the disorderly conduct, specifically as it relates to Section A8, which is displays a firearm in a manner calculated, or other deadly weapon in a manner calculated to cause alarm. So, and what I'm going to tell you is the case law is overwhelmingly against Olmos Park, and anyone with a brain, which is probably why they haven't figured this out yet, knows that what they're doing is wrong, because the elements of these crimes are well established and easy. Okay, you have to obstruct a roadway. So we're going to start, and this is Texas Penal Code 4203 is the relevant statute here. And the first case that I want to talk about, and I'm not going to go through all of them. Like I said, I pulled out a pretty healthy list. I stuck it in the video description here. And some of these cases don't even specifically deal necessarily with that particular element, but that's one of the many elements of the case. So the first one's Davidson v. City of Stafford. Actually, I'm going to go backwards. That's my last case because that's 2017. In 1981, there was a case, and this one is Sherman v. State. And a lot of these other cases I'm going to discuss, they reference Sherman. So Sherman is a case that is what we call shepherdized quite often, that is used to back up a lot of decisions by the courts. And it talks about, so in Sherman, this was a picket dispute. Okay, one of the unions was doing a picketing, and this guy was arrested. Sherman was arrested because one of the things he did while he was picketing was he was walking slowly across the driveway where vehicles were entering and exiting. And he was just walking. But then when a car would come in order to, I don't know, delay them or something, the officers were called because the business that was being picketed by the union didn't like the fact that these people were picketing, essentially, and said that they were disruptive and all that. So the police show up. The police sees Sherman, and they're monitoring this thing. And Sherman, as a car is getting ready to leave or enter, I can't remember which one it was. I mean, I got the case right here, but I'm not going to read the whole thing. It doesn't matter. He got in front of the vehicle, and he was walking, but as the vehicle pulled up, he like slowed to kind of a half step and like slowly crossed the road. And thank you for the $2. I'm sorry, I didn't see who that was. Here, let me go up here because I like to. Hey, Ricky, thank you, man. So he was slowly in front of the vehicle. So he kind of like delayed them, right? So he was charged under 4203. He's actually charged under a picketing statute, but the court referenced 4203, which is the one that Jack is charged with. And here's what they said. At most, this is what the Sherman court said, at most, the proof showed that the appellant caused a momentary hesitation of a vehicle entering the struck premises. It was a strike. This is simply not enough to support a conviction under the statute as we construe it. So, and I'm building on stuff. So there's a reason I'm bringing up the Sherman case. Because the statute that he was brought under, which is a picketing statute, references 4203 to define the word obstruction, right? And the word obstruction, according to the court, is the rendering impassable or the rendering unreasonably convenient or hazardous to the free ingress or egress of the struck premises. Okay, and again, this is a striking, but that's what obstruction means. So to obstruct a roadway, right, you have to meet that, you have to render impassable or render unreasonably inconvenient or hazardous the free ingress or egress, okay, of an area or a place or whatever. So I know some people are like, well, CJ, he was on a sidewalk. He wasn't blocking traffic. So that case is irrelevant. Well, it's relevant because it talks about what to obstruct means. I have a case. Again, this is in the notes there. This is Haye v. State. So in Haye v. State, Haye was observed on a sidewalk, and apparently it rained or whatever. Yeah, Jack is out now. Apparently it had rained, but he was just standing on a sidewalk. Now, this guy's a douchebag. Don't get me wrong. I'm not defending any of these people. I'm just telling you what the law says. So he's standing on a sidewalk, and this elderly man is walking by, and Haye is standing in the middle of the sidewalk. And it's a fairly wide sidewalk. However, on each side of where Haye is standing, it's muddy. And so the only way that the elderly man can get past is by going through the mud, okay? This muddy area. And so an officer observed this. He told the guy to leave or whatever. Well, initially he was told to leave, and then he came back, and that's when the old man thing happened, because he was obstructing a sidewalk. And so in this case, again, and it quotes Sherman, which is why I brought up Sherman, because I wanted you to have the base, because it defines what obstruct is. But the fact that in this case, you'll notice in 4203, this guy was charged and convicted because he blocked a roadway. He made it unreasonably inconvenient. This is the word that they used. Obstruct means to render impassable or to render passage unreasonably inconvenient. And everyone will admit, a reasonable person will admit, that if someone is blocking a road or a sidewalk or an alleyway, because there are some of the cases I list talk about an alleyway, and you have to go through the mud to be able to do that, that's unreasonably inconvenient. Okay, that's obstructing. Jack was not doing any of this at all, none of this stuff. And so here's this next case, and then I'm going to tie this all together to Jack. What I'm doing is kind of doing a quick history, and then I'm going to tie this together with what happened with Jack and what he's being charged with. So this is Davidson v. City of Stafford. This is just a couple years ago, 2017. And for those of you just joining us, all these cases and more, because I'm not going to go through all of them, are in the comments or in the video description. So in this case, we had an abortion protester. He was out at, and this is the case I think that is most relevant to Jack's incident. Okay, this is the one that I think is going to most, well, the other one as well, but only as a distinguishing case, because in the case I just read, the case of Haye, the guy was obstructing a sidewalk, okay, because he was making it to where people couldn't get around conveniently. This case here that I'm about to talk to you about, this is the Davidson v. City of Stafford case, is I think the one that is most applicable to what happened to Jack. In this case, you've got an abortion, but Jack wasn't protesting abortion, I know that. But you've got an abortion protester, and what was happening was this guy was approaching people and trying to talk to them that were going into an abortion clinic and trying to keep them from, trying to give them information and things like that. Well, what the abortion clinic owner did was, of course, call the police and say that he was he was delaying them. Here it is. Because by asking questions, he was delaying them. All right. So the officers found out that he might have slowed people down that were entering the parking lot because he wanted to speak with them and offer them informational cards and try to encourage them not to murder their babies. But the court said, while these actions are considered inconvenient based on the description that was given by the abortion clinic, they cannot be construed by any objectively reasonable officer as rendering entry to the clinic impassable or unreasonably inconvenient as required under the statute. And this is the statute that Jack is accused of. Davidson was walking, approaching. This is what the abortion clinic was trying to say. Davidson was walking, approaching, harassing, or delaying clinic patients, but he wasn't stopping or preventing their entry into the clinic. This distinction of movement by the defendant. So the defendant is walking with these people as he's talking to them, trying to keep them from going into the abortion clinic. This distinction of movement by the defendant, as opposed to the defendant standing in place and making a pathway impassable requires no finding of obstruction. And then it quotes, of course, the Sherman case, which I just read. That's why I brought that up to you. And in Sherman, it said there's no obstruction where a defendant caused a momentary stop by walking in front of a car. And then you've got there's a couple of cases here. If no reasonable police officer could have believed that, I'm sorry, I'm on a completely different thing there. But there are other cases here about, so Rolf v. City of San Antonio, and actually I don't think I put these in the description, so I'll update these in a minute here. If no reasonable police officer could have believed that probable cause existed for law enforcement actions against the plaintiffs, then their retaliation violated clearly established laws of this circuit. This is a Fifth Circuit case. This is Rolf v. City of San Antonio. Wow, that's pretty close to Olmos Park. So in Rolf v. City of San Antonio, they recognized there was no probable cause for this arrest of Jack. None at all, because there was no obstruction. He was not blocking the sidewalk from anybody, and he was moving. He even told when the officer, I don't know if that's a weird, when Chief Valenciano told him to move, he was moving, just not in the direction that the police officer wanted him to. And so when he went to arrest Jack, he did so knowing that there was no probable cause, and this was simply retaliation. There's another case that Faust v. State. There is no dispute that the protesters had a First Amendment right to express their views in a public forum, and this is them being on a sidewalk. Another one, Iranian Muslim organization versus the City of San Antonio. You know, it's funny, the City of San Antonio has a lot of problems with this, using this obstruction of a roadway. I have to wonder if San Antonio and the suburbs have been educated and trained on just arresting people for being on the sidewalk and protesting when they don't like it. The Iranian Muslim organization v. City of San Antonio, this is a 1981 case. The right to picket and demonstrate in public places, particularly streets, sidewalks, and parks, are extended First Amendment protection. He has a right, Jack has a right to protest against the city of Olmos Park on the sidewalks, as long as he doesn't obstruct them. And we've already gone through the case law about what obstruction means, and he did not obstruct anything. So what we have in this case, and I think those are the only ones I really wanted to necessarily cover, because a lot of the other cases that I included in the video description say a lot of the very same thing. You've got Kraft v. State, Hardy v. State. Actually, I think I talked about Kraft a little bit. But you've got, you can go and read up on all of those. What happened was the people that, if you watch the video, and this is where it's going to hurt Olmos Park because it's obvious there was no probable cause. When what I think was happening, this is just my opinion, was the city workers, because this was around the time they got off work, were leaving the building, and Chief Valenciano probably has everyone hyped up at Olmos Park thinking that people who believe in the Constitution are terrorists, and he's been able to successfully scare all of the employees into thinking that their lives are in danger. And so he was probably escorting the people from the office, from the police station, to the parking lot where their vehicles were parked. And so what he probably wanted to say was that that Jack was obstructing the sidewalk, allowing these people to get back to their vehicles. Well, you can obviously see that Jack and Patrick and everyone is moving out of the way, and while they're interacting with the police, you'll notice the employees continue on. They're not inconveniently made to go somewhere else. They're not slowed down, and even if they were slowed down, I have already read the case law that just because someone like slowly walks in front of you and you get momentarily slowed down, that does not constitute an obstruction. So it's going to lose on its face right there, the obstruction of a sidewalk. And every single time Olmos Park has tried to use this statute, it has failed. Every single time the charges have been thrown out. And at some point, Olmos Park needs to be held accountable for some kind of tortious, malicious prosecution. All right. All right. The next thing I wanted to get into, and this is my favorite because, and I'm probably one of these days, if I have time, probably my second year of law school, write an extensive letter or I'm sorry, an extensive paper, probably for law review about disorderly conduct statute. And this is 4201A8. This is what they all love to do. They all love to try and say, oh, if you carry a rifle, it's disorderly conduct because you're carrying in a manner calculated to cause alarm. But our case law is very clear about what this means. There are several elements to the disorderly conduct statute that Jack is charged under. First of all, you have to carry a firearm or other deadly weapon. You have to carry a firearm or other deadly weapon. That's the first thing that has to happen. If you're not carrying a firearm and you're not carrying a deadly weapon, and the firearm or the deadly weapon is the subject of the disorderly conduct, for example, let's say Jack also had a concealed handgun, a real handgun on him, or a knife or some other deadly weapon, then you still could not charge him with disorderly conduct because in Jack's case, the subject of the disorderly conduct was the airsoft rifle that he had, the toy gun that he had. Okay, and there's nothing deadly about it. It's not a deadly weapon. Nobody can argue that it's a deadly weapon. No reasonable person can argue it's a deadly weapon. And he didn't have a firearm. So right there, and I'm going to go through all the elements anyway, but right there, you've already missed the key element to disorderly conduct, which is that there is a firearm or a deadly weapon. Neither of those Jack had. The minute that Chief Valenciano threw Jack on the ground and his plastic gun became 4 pieces of plastic because it broke, then there you go. Now, I actually have a case. As a matter of fact, I was going to hold this one, but this was going to be my second case, but I'm going to bring it up first. So there is a case. This is the In Re KH. Now, this is in reference to KH. KH is a minor, which is why you don't get a name in this case. So when you have a minor in case law, the minors are generally referred to by their initials and not by their full names because we try to protect minors in our society. Now, he was charged with many different things, okay, and he was charged for good reason for the other crimes, but he was also charged under 4201A8. Now, what happened was this kid brought a pellet gun to, I believe it was school, actually. Yes, he brought a pellet gun to school, and he was showing it to his friends, and he took it out, and he pointed it, and he says, if you tell anybody, I'm going to use this on you, okay? That would have been disorderly conduct, but it was a pellet gun. And because when you point a gun at somebody and you say, you threaten them, that's kind of what the statute is intended to do. That's what the legislature intended when they created that statute, is they don't want people going around, and I'm going to show you what the intent was, because I've got a case that actually shows you the intent and an actual case that meets it. But obviously the legislature doesn't want people going around shoving guns in people's faces and scaring them, okay, for any reason. But in this case, this kid threatened another kid that, if you tell anybody about this, I'm going to use this on you. But the court stated, this is the In Re case, In Re KH. I think this is 1980. Nope, this is 2005. As stated above, the gun in this case clearly was not a firearm, and therefore 4201A8 does not apply. Okay, so in this case, the first court pointed out that the investigator testified the gun was capable of inflicting serious bodily injury. We have no such evidence. All right, so Jack had an airsoft at best. I'm not even sure exactly what kind of gun it was. All I know, it was a plastic gun. It wasn't a real gun. It wasn't even a pellet gun, which shoots out metal pellets. It was probably an airsoft gun, and probably a cheap one at that, the way that it broke in that way. So there was no firearm. Case law has already said that 4201A8 only applies to a firearm or a other deadly weapon, and that's not going to work. It's not going to fly. there's several cases about fake guns. As a matter of fact, in the Greaves case, actually, I'm going to go to that now. I'm kind of going out of order here. In the Greaves case was the next one I was going to talk about. So in Grieve v. State, what happened was the police were called because someone had called and said there was somebody showing a gun up in a balcony, on someone's balcony, okay? So the police show up at this house, and they knock on the door, and they ask about, hey, is there a gun here? And he says, I don't know what you're talking about. The roommate comes in, and he's like, oh yeah, I have a gun in my room. And he runs to his room to show the gun, and the gun is a plastic handgun. It's a clear, let me see if I have the actual description of it, but I didn't highlight this whole thing because here it goes. The officers asked the appellant about a gun in the apartment. The appellant told them that his roommate had a toy gun. When the officers examined the gun, they determined it was a plastic pellet gun, okay? And they tried to get him under 4201. Now it comes to find that this is actually a Fourth Amendment case, because what happened was when the officers heard that he had a gun and he went to go get the toy gun, the officers charged in because even though they had told him it was a toy gun, the officers charged in. When they charged in, they found like a small amount of marijuana, and they ended up arresting him on drug charges. And he got out of the drug charges because there was no probable cause for them to go into the room to begin with. Because even if it was a real gun, he was not in a public place because the gun would have been shown on a balcony. It wasn't pointed at anybody. It was just somebody saw it. And the court says that although the state maintains the fact that someone called the police, and this is what's important, because a lot of these police departments, Olmos Park especially, because in my case, they tried to use this example, they try to say, well, someone called, so obviously someone was alarmed, and therefore you're guilty of causing alarm under 4201, disorderly conduct. But listen to what the court says about that. Although the state maintains the fact that someone called the police is sufficient to show that the gun was displayed in a way calculated to cause alarm, we cannot agree. That's what the state was saying. The mere fact that the police were called is not evidence in any way or of the way in which the gun was displayed, nor is the mere fact that a person who saw a gun displayed on the balcony evidence that the balcony was in a public place. So just because someone calls the police doesn't mean that you're carrying in a manner calculated to cause alarm. It just does not work that way. And again, you've got the issue of the fact that it was a plastic gun. Now, they didn't go into super detail in the Grieve case about 4201 because it was kind of an aside. The case was about a Fourth Amendment motion to strike evidence because the officers had no probable cause to go into the apartment because no crimes were being broken. They had no reason to go inside and search because the call itself was not probable cause, and the fact that they were told it was a toy gun and then he went to go get it for the officers, and instead the officers unholstered their guns and started going in and doing a search, and that's when they found the drugs. So Grieve kind of got away with that in that sense. All right, there's the Grieve case. And the Grieve case is actually a very big case for open carry of long arms because just anytime the officers try to claim that, well, someone called, so therefore you're guilty, well, the court's already ruled on that. All right, now we got Roberts v. State. This is a 2016 case. So another one. Where can I get one of those morale patches? Oh yeah, these are all I trade these out. I have so many patches, and I wear these to school, and I trade them out. I've got different ones. I got one that says this is my non-offensive patch, but I try to yeah. You can get them at gun shows. You can get them online. You can get them on Amazon. Shoot, you can even get them on the Wish app. I've gotten a lot of my patches from the Wish app. Anyway, I'm sure if you just do a search, you'll find this one, the one that I'm wearing right now. Let me put that up there. All right. So where are we at here? We are on the Roberts case. All right. So 2016 Roberts. This is the case that I think is the quintessential case about what the legislature intended when 4201A8 was passed back in, it was either 69 or 71. I actually looked into, one of the things I did last night was look in, oh no, I'm sorry, I'm thinking of another case. Never mind, forget that. I don't know when this one, I didn't look into when this case or when this law was passed. I was actually looking into when the law was passed about you can't resist an unlawful arrest. That's a whole nother video coming up, by the way. As an aside, Texas is the only state in the Fifth Circuit with a law that says you cannot, and yes, this is Texas law, you cannot resist an arrest even if the arrest is unlawful. It's not a defense, but only in Texas. Now, I think that law, and I could not find anything challenging the constitutionality of that section of the law. That's some research I'm going to do a little bit later. But I think there is a case to be made all the way up to the Supreme Court, if necessary, that the Texas law that you cannot resist an unlawful arrest, I believe that's unconstitutional. I think it violates our Fourth and Fifth Amendment rights. Anyway, that's a whole other issue. But I ended up on a sidetrack last night. I was looking up that law, and that law was passed in like 69 or 71 or something like that. And the purpose and the reasoning, think about what was going on back then. Back at that time, the Vietnam War was raging, and people who were protesting the Vietnam War were being, and don't pay any attention to whether or not you agree with the protesters or don't agree with the protesters, whether you agree with the war or you don't agree with the war. The fact of the matter is people were exercising their First Amendment rights to protest the war, and the police and the state didn't like it. They wanted to teach these hippies a lesson, and they passed the law that said, because of course people were getting arrested for no reason whatsoever, and the hippies were resisting it. And so what does the state do? The state passes its resisting arrest law with the section that says it is not a defense that the arrest was unlawful. So only in Texas, in the Fifth Circuit, we are the only state that our law says that you cannot resist an arrest. Meanwhile, several states in the Fifth Circuit explicitly have in their law that you can use reasonable force to resist an unlawful arrest. That's a whole other video. I just wanted to let you know that, okay? I think it's an unconstitutional law, and obviously unconstitutional laws have no fact, and I will always resist or oppose an unlawful arrest. If you are unlawfully arresting me, you are searching and seizing me against my constitutionally protected rights. I'm going to resist you, and then I'll just take that fight up. I haven't been able to take that fight up because every time I've been charged with resisting or interference with an unlawful arrest, the charges get dropped. All right, back to what we were talking about here. The disorderly conduct statute. And I'm almost done, all right? Because after this, I'm going to talk about a potential problem with the disorderly conduct statute with a case that's percolating up, but it might not be a problem. It's definitely not a problem in Jack's case. So this is a 2017 case, but it's a 2015 incident that happened. And this is the Roberts v. State case listed in the description below. I think that this is an unpublished opinion, but it is from the Court of Appeals, okay? But in this case, an individual was at a car wash. He had pulled his truck up to get it washed, but before he went through the car wash, he was trying to do some pre-cleaning in his truck. Well, while he was pre-cleaning the truck, you know, kind of getting rid of the trash, throwing the trash away, perhaps knocking off some of the big mud and all that kind of stuff. While he was doing that, another vehicle pulled up behind him. And this was the defendant, or the appellant in this case, Roberts. So he pulls up behind him and while he's cleaning, and the appellant asked, Roberts asked the guy that was cleaning out his truck if he was an attendant. And he says, well, no, I'm just cleaning out my car. So the guy says, Roberts says, oh, so you're just in the way. He told him he was trying to hurry, but the appellant, the guy was cleaning out his car. So his name is Turnwire. Turnwire was trying to clean out his car, and he's like, look, I'm trying to hurry, but the appellant obviously appeared very displeased by this. So as Tenwire was putting away the brush he'd been using to clean his truck, appellant Roberts yelled for this guy's attention. And when he turned around, he looked up, and Roberts was pointing a shotgun at the guy. This is how you carry a firearm in a manner calculated to cause alarm, because why would you point a shotgun at somebody if not to alarm them that you were going to shoot them? And of course, he was rightfully convicted under 4201. I just wanted to kind of bring that up as an illustration of what the intent of 4201 is, because all the cases that people were convicted under 4201 A8, carrying a manner in carrying a firearm or other deadly weapon in a manner calculated to cause alarm, were because someone pointed a real gun at someone else in order to scare them. I think every reasonable person in the world recognizes that, yes, that is probably a good indicator of what it means to carry a firearm in a manner calculated to cause alarm. But it has to be a firearm. All right, last thing. This is the problem that you may have heard about, this Ross case. This is State v. Ross. This is the one that kind of has open carriers really worried right now. I am not worried, especially in Jack's case. I'm not worried because, again, regardless of what the term calculated means and regardless of what the term alarm means, it doesn't matter in Jack's case because Jack did not have a firearm, period. You don't even have to do the analysis of the word calculated. You don't have to do the analysis of carry. You don't have to do the analysis of the word alarm because there's no firearm involved. And the word firearm is required. And let me do something here real quick. There we go. Let me do this. All right. Because none of that matters if you don't have a firearm. The firearm is the quintessential element of 4201A8. Okay? If you don't have the firearm, none of the other elements matter because that is a required element of the charge. Now, in State v. Ross, the problem with this case is there are a lot of problems with this case, and I don't think it's going to apply to open carriers, okay? But there is a lot of worry that it can, and I can see the pitfalls of State v. Ross becoming some sort of precedent in Texas. But I don't think it will because I think this is going to be a distinguished case, not a case that actually helps make any arguments for going after people who open carry. But there are some problems with the way that they define the words calculated to alarm, okay? The problem in this case is, and this is Devontae Ashawn. So Devontae Ashawn, this is what the case doesn't really tell us a whole lot about what he was doing. But from what I've been able to read, this guy's been involved in gang activity and things like that. So this isn't exactly what we would call a sympathetic defendant when you're talking open carry issues. But the way I read this case, and I've read both this is out of the Court of Appeals 4th District, and I've also read the Court of Criminal Appeals. So there's this is the 4th District Court of Appeals, and this is the Court of Criminal Appeals case law where it was appealed. It appears to me because there's really... All right, let me back up. This is what he's charged with. On or about the 8th day of June 2016, Devontae Ashawn Titus Ross did intentionally and knowingly in a manner to alarm display a firearm in a public place, to wit the 300 block of Ferris Avenue. Now the problem here is that it doesn't say exactly what that means. Was it a handgun? Was it a rifle? Was he holding it in his hand? Was he pointing it at somebody? There's literally in all of these cases, there's no discussion whatsoever about exactly what Devontae was doing with the gun or what kind of gun it was. But I'm led to believe that this was a handgun issue, okay? I think this was a handgun issue, and I think he was pointing it at somebody, all right? Just based on what happened. So the trial court, what happened was Devontae's attorney challenged the information as failure to state a claim. All they did was recite what the code is and say, okay, well, Devontae intentionally knowingly in a manner calculated to cause alarm, display a firearm in a public place. But it didn't exactly say how. And what the attorneys were trying to argue was, how's my client supposed to know? This doesn't say exactly what he did that violated the statute. How is my client supposed to know when he carries a firearm in a manner calculated to cause alarm if you didn't say in the information, the charges, exactly what he did to do that? All they literally did was say he violated the law because here's the law, but it didn't say what actions violated the law. And so that was the argument in this case. It's a very weird case, and this is why I don't think this hurts open carriers, because a lot of open carriers, when this case first hit last year, when this was decided by the Court of Criminal Appeals last year, a lot of open carriers were really distressed about, oh crap, now we can't carry a gun. And I'm gonna tell you why. What language caused that? But that's the issue. So the trial court, when they filed a motion to dismiss because they failed to state a claim, they dismissed it, and then the state appealed, and the Fourth Circuit agreed with the court and dismissed it, and so the state appealed again to the Court of Criminal Appeals of Texas, and that's where things get bad. That's where things get bad, because this is where the court starts writing what it believes calculated to cause alarm means. And again, I'm gonna put this up here because while I'm saying this, I want to preface it with none of this matters in Jack's case. None of it matters because, again, there was no firearm involved. So Jack's case is already thrown out, but I think we need to have a good discussion about what manner calculated to cause alarm is, because the Ross case it adds an element that is potentially destructive. But I don't think it's going to apply to most open carriers. So the Court of Appeals found that the term alarm was unconstitutional because, quote, conduct that alarms some people does not alarm others. That's a very good, astute observation there. And then, of course, in Kramer v. Price, the Fifth Circuit had already said that the term alarm is inherently vague. Well, what this court is essentially doing is sort of overturning all of that, and it says that it quotes the Supreme Court, the Texas Supreme Court, in saying that calculated can be reasonably understood to mean either a planned or contrived to accomplish a purpose, or else simply likely. Calculated just means likely. So now what the Court of Criminal Appeals is saying is that the statute really doesn't say if you carry a firearm in a manner calculated to cause alarm. It's if you carry a firearm in a manner likely to cause alarm. That's how the Ross court is interpreting this. And again, I think we're dealing with a handgun case here, because the court does go into quite a bit of discussion about the holstering requirement. And if it was a rifle, they wouldn't talk so much about the holstering requirement. So down on page 14 of the decision, it talks about 46035 that it's an exception if it's carried in a shoulder belt or shoulder holster, and there's like paragraphs about that. But in any event, in both of these circumstances, so this is it. Okay, never mind. I'm sorry. It actually specifically says that. I knew there was a reason why I thought that. So in the Ross case, we're talking about a handgun. And the handgun was not in a belt or shoulder holster. And that's why they're using the carrying a firearm in a manner calculated to cause alarm. Because if it's not in a holster and it's in your hand, a reasonable person would probably be alarmed by that. Because why would a person have a gun in his hand if he wasn't about to use it? A handgun. So I don't think they can't use the Ross case and not a rifle that's slung. And it was slung on his back. The Ross case would not apply, in my opinion, because the Ross case is specifically about a handgun that is not in a holster, okay? So I know there were a lot of people who have talked to me about how the Ross case might hurt Jack. I don't think it will, for two reasons. First, I've said it this entire video, and I'm going to end it with this. First is that he wasn't carrying a firearm. I think that's the deadly killer of Almost Park's argument. The firearm thing. It doesn't say carries a firearm or other deadly weapon or something that looks like a firearm. It says firearm or other deadly weapon. What Jack was carrying was neither. So that's the first thing. The second thing is that the only case that the prosecution can rely upon to even stretch the imagination of what would constitute a 4201 violation is the State v. Ross case. And I don't think that's going to be a good argument for the state. And if I were the defense attorney, I would argue that this case is distinguished from Jack's case because the court was specifically talking about a person with an unholstered handgun in his hand, talking about calculated to cause alarm. I guarantee you, if you walk around public and you've got a handgun in your hand, and I think any reasonable person would feel this way, that's probably more likely, since that's what the court is saying the word calculated means, that is more likely to cause alarm than someone who's got a rifle on his back. Okay? So I don't think that case is going to help him, and that's really the closest that Olmos Park or any prosecutor is going to be able to come to try and charge Jack under 4201. So we've already gotten rid of 2 charges, and that's the 4302 or 4203, excuse me, obstruction of a sidewalk. That's going to go away. I've already proven it with all the case law. I've sent Jack all of this case law to provide to his attorney. I've done a lot of the work for him. So we do have, by the way, I think I got Jack an attorney for a pro bono attorney that's going to help him, and so that's going to go away. I also sent Jack all of the 4201A8 stuff so that they've got all that case law. That's going to help them. I do have some case law here about this was resisting an unlawful arrest. The problem is that even though it's Fifth Circuit, which means that it applies to Texas, it's Fifth Circuit case law, it's based upon Louisiana and Mississippi and Oklahoma laws. And those states specifically allow resisting unlawful arrests with reasonable force. So you can't just like start shooting people because someone's trying to arrest you. So for example, like what I would have done, assuming that I was under arrest, because no one told me I was under arrest when Jack Wagon Valdez was trying to grab me, that probably that would have been fine because it was reasonable. I wasn't hurting anybody. I wasn't hurting anyone. But I don't think any of this stuff is going to stick. None of it is going to stick. The video shows that he didn't assault a peace officer. That's easy. That's going away. Hey, what's going on, Yukon? I've already explained why the disorderly conduct's going away. I've already just explained why the obstruction of a roadway is going away. And the only other one is resisting arrest. And again, I think if they keep that, which he wasn't resisting an arrest. The minute that Valenciano grabbed him, okay, he didn't say anything. He didn't say you're under arrest. He never told Jack, you're being detained, you're under arrest. All he did was he goes up and starts grabbing him. And Jack's like, oh, leave, don't touch me. But the moment that Valenciano grabs Jack's wrist, there's absolutely no, that was after. That was after he grabbed him. I'm saying before he grabbed him, there was nothing saying you are detained or you are under arrest. Once he grabbed him, Jack didn't resist at all. Once he had mentioned that, I'm sorry, I don't remember seeing that at all. But it doesn't matter. The point of the matter, Jack did not resist any arrest, and a detention is not the same as resisting arrest. You can't resist an detention. You can only resist an arrest. If you're just being detained, and then you say, I'm out of here, and then they say, okay, well, now you're under arrest, that's different. But Jack was never told he was under arrest, and so you can't resist an arrest that way. That's it for y'all. Is there anything I can now pay attention to because I'm not going through case law? Let me look through here and see if there was. Oh, John, did you get the case law back? But yeah, there was no arrest. Even if he had said though that you're under arrest or you're being detained, Jack never resisted. all he did was try to say, "Don't touch me," and that's when he said, "You're." That's whenever he said whatever. At the same time, I think he was grabbing his arm. All right. Any other question about that? All right. Let me end this by saying, once again, I said this at the beginning of the video. I am not an attorney. I am not giving legal advice in any way whatsoever. Okay, so he said it as he was grabbing Jack. Gotcha. So again, there was no resistance, no resisting arrest. So I think that's going to go away as well. There's literally no case, and I think Valenciano knows this. I think Valenciano knows that there's no case. But if you look at, go and look at Justin Pulliam's video that he just put up, where he actually has on camera Valenciano saying, "Oh, you're going to know when I hurt you." And that was 2 days prior, I believe, to the incident that just happened. "Oh, you're going to know when I hurt you." So I think that what Valenciano knows, there's no issue at all. And again, go look at Justin Pulliam's video about this. That he has a great video of all the issues of Olmos Park for the last few years that we've had with the tyranny that's going on there. And I think all Valenciano wants to do is he recognizes that, you know what, I can't beat them in court. I don't like them. I don't like the fact that they're standing up to me. But it's that you might beat the rap, but you're not going to beat the ride. And they know that he's not going to get his bond money back. He's not going to get his bond money back, even if all the charges are dropped. And unless he sues, which is extremely expensive, trust me, I know, we're still suing Olmos Park. And I'm telling you, it's extremely frustrating, but I want you to know we're fighting them, and they are playing hard to get. All right, I'll leave it at that. But that's what this is. This is contempt of cop, and Valenciano wanting to teach Jack a lesson. And let's see, Valenciano said, "Go across the street." Jack said, "I'm going across here." Then Valenciano says, "You're detained while grabbing Jack." Yeah, while grabbing Jack. Gotcha. All right, appreciate it. I knew he never said he was arrested, and I'm pretty sure he didn't say you're being detained prior to anything going on. But yeah, and there was no legal. The state had no legitimate interest, right? So when Valenciano told Jack to, and I'm not going to make this more than an hour, so this is going to be over in 6.5 minutes, whether I'm done talking or not. When Valenciano told Jack to go across the street the other way, there was no legitimate state interest in forcing Jack to go across the street the other way. Jack had every right to walk to the right, to walk to the left, to walk forward, or to walk back. I talked about the case where the court specifically said he didn't stop and obstruct anything. He was walking. Jack was moving. Jack was even obeying the orders. He just wasn't going the direction that Valenciano specifically stated. And the state, when an officer of the state issues a directive, the state has to have an interest in issuing that directive. There has to be a state interest for it. What was the reason and the purpose? Because if the chief was trying to protect the people that he was out there protecting as they walked to their vehicle, those people were already gone. As a matter of fact, they were gone to the camera's left. Jack wanted to go to the camera's forward. Which would have been away from the very people that the chief is probably going to claim he was protecting, because the chief has told them that their lives are in danger because of Jack and those First Amendment guys who are oh so dangerous. So there was no legitimate state interest in preserving the public peace and preserving the public safety in ordering Jack to go one way instead of another. Jack was moving towards the sidewalk, absolutely. Jack was moving towards the sidewalk. He actually even pointed. He's like, "No, I'm going to go this way." Pointed at the sidewalk and made very clear which way he was going to go on a public road. But the chief just didn't like that. 2 days earlier, the chief had specifically told him that he'll know when I've hurt you, and he let Jack know that day. Okay, remember I said you'll know when I'm going to hurt you? Now you know. All right, guys. You guys take care, be safe, be free. I kept this under an hour, but I hope y'all learned something. I hope this was educational and informative. I will add a few more cases to the video description after I'm done with this. And yes, Redneck Dad, if this goes to court, you better believe that's going to come into play. If I were a defense attorney, I would show that that's premeditated assault. I mean, that's aggravated assault with premeditation because 2 days prior, he even said he was going to hurt Jack. Does Texas have a law about defending yourself against a cop? So, free citizen of Texas, yes. You are able to defend yourself against excessive force. State law allows you to defend yourself against excessive force. Okay, not force, but excessive force. So it depends on what that is, and it's obviously it's up to interpretation about what's excessive. The city or the state will always argue that, and it depends on the severity of the crime as well. So, for example, if they're beating your ass over a speeding ticket, or because let's say you refuse to ID, right? And you're only accused of, I don't know, not having a reflector on your bicycle. Well, if they start beating you, that's excessive force. Now, if you if supposedly you just committed an armed robbery on a bank and they're trying to stop you, you're obviously a potentially violent person. The excessive force can be higher depending on that. So the answer, the legal, and again, I'm not giving legal advice. I'm telling you the law in Texas is that you can defend yourself against unreasonable and excessive force. But that force that you defend yourself with also has to be reasonable and not excessive, and it has to kind of meet. So there you go. And good luck if you do defend yourself. Just make sure you're right. I guess is all I can say. Make sure that you're really right, and make sure that the cop is really wrong, and always be a sympathetic defendant. When you're being abused by the system, and I know this firsthand because I've made this mistake. I've grown a lot since I became an activist. When you're being abused by the system, you are going to go before a jury, and your life is in that jury's hands. If all you're doing is cursing out the police and calling them names and denigrating them, even while they're violating your rights, and I can understand using some profanity, but I'm talking about specifically denigrating the officer, baiting, and all that kind of stuff. When that goes before a jury, they're going to look at that, and you might be 100% right, but a jury is going to sympathize with the cop. And you want the jury to sympathize with you. So always try to be what I call a sympathetic juror anytime you're interacting with police. Stand up for yourself, defend your rights, don't give in, don't identify if you don't have to, don't answer questions, do those things that you should do, but make sure that you're not becoming someone that when the jury sees the video of you, the jury is like, oh my gosh, what an asshole. Now instead of them actually having pity on you for the fact that you got your ass kicked or that your rights were violated, they're just like, what an asshole, he probably deserved it. And we all know there are all those bootlicker people out there, those people who think that the police, their shit don't stink, and therefore, they'll always give them the benefit of the doubt. But if you don't give them that reason by using profanity and other kinds of stuff, if you look, I'm just trying to do the right, I just don't want you to violate my rights, and you look like the sympathetic person, then you're more likely to win, okay? But you're more likely to lose even when you should win if all you're doing is using profanity, cussing people out, and being an ass. Now, there's nothing wrong with being an ass. You have a right to be an ass, by all means. Be an ass if you want to be an ass. I'm just telling you, it's going to make your life harder. It's going to make your attorney's life harder, and you're probably going to lose your case, not because you should, but because a jury's just not going to like you. And unfortunately, that's just the way it is. Thankfully, Jack was doing nothing wrong. Jack was not using profanity. He was not yelling names. He was not. So I think in this case, when the videos come out of this, that Jack is going to be a very sympathetic witness, especially in light. Okay, I'm at my hour mark. I'm going to leave that. If you guys have any further questions, my email is cj@cjgrisham.com, cj@cjgrisham.com. And I will try to answer those. Remember, I'm in law school, and I got 2 hours of sleep last night. Well, this morning, because I got home at like 4:30 or 5. So just please don't ask me for something. It's going to take a lot of my time because law school is hard, and I want to be able to graduate as a great attorney, not just graduate with a degree. There's a joke. What does what do you call the person who graduates law school last in his class? Well, you call him attorney. I don't want to be that guy. I want to be the guy that graduates from law school and knows how to fight for civil liberties and how to defend most of you people. Because that's what I'm in this for. I don't want to do corporate law. I literally only want to do constitutional law. I want to do criminal law and civil law, where I defend people who are falsely arrested and then help sue cops. I've even bought, when I get a law firm, I already bought the my website for my law firm, but that's what it's gonna be. I still have to pass the bar. You're right, and that's the hardest part. Okay, guys, take care. Be safe. Be free.